On June 24th, 2022, USCIS issued a new policy on the 3-year bar and the 10-year bar that allows immigrants to adjust their status even if they have been inside the United States during this period. This update is made in response to a couple of recent court cases in which several immigrants brought a class action lawsuit against USCIS after having their adjustment of status applications denied due to the 3 or the 10-year bar. There has been a lot of confusion about this court case and the resulting USCIS policy update. So in this video, I will take the time to explain the details of this case, what the US policy means, and who it will specifically apply to. And if this is your first time on my channel, be sure to subscribe and turn on your notifications so that you can be updated with the most important immigration news as soon as it comes out. And if you would like to get my help on your case, call my office for an evaluation at 212-248-7907. The class action lawsuit responsible for this new policy change is De Gomez versus USCIS and was filed on March 25th, 2022. It included 5 plaintiffs who had their adjustment of status applications denied by USCIS because they were present inside the United States during the course of their 3-year bar and their 10-year bar period. For example, the plaintiff for whom the case is named, Miriam Velasco de Gomez, is a non-citizen from Mexico who lived in the United States for more than 20 years and has 2 U.S. citizen children and 2 lawful permanent resident children. Ms. Velasco entered the United States with her B2 visa in June of 1996. However, she remained for more than 3 years and left in March of 2000, which means that she violated her visa and overstayed. Because she had accrued more than 1 year of unlawful presence, as soon as she left the United States, she triggered what is called the 10-year bar to re-entry. Ms. Velasco then entered the United States on April 8, 2000 on another B2 visa and remained in the United States ever since. On July 19, 2018, almost 20 years later, she filed her I-485 application to adjust her status, and her U.S. citizen son filed an I-130, listing her as the beneficiary. USCIS approved Ms. Velasco's I-130 application by her son in March of 2020. However, on the same day when she had her interview, she was sent a request for evidence citing that she was subject to the 10-year bar and to prove that she was otherwise eligible to adjust her status in order to receive her green card. Ms. Velasco quickly responded, asserting that she was no longer subject to the unlawful presence bar because 10 years had already elapsed. However, USCIS asserted that she had to be denied her application because she served out her 10-year bar inside the US instead of outside. In her appeal, Ms. Velasco argued that more than 2 decades had passed since her last departure after triggering her 10-year bar, and this was still dismissed by USCIS. The important thing to note is that the Immigration and Nationality Act does not actually say specifically that this bar can only be served as time outside the U.S. After this lawsuit was filed, the court disagreed with the decision of USCIS, essentially concluding that a non-citizen may reside inside the U.S. while waiting out the 3-year or the 10-year bar, and forced USCIS to change the way they are applying the law and formally update their policy. So what does the new USCIS policy say, and who does it apply to? According to the policy update issued on July 24th, a non-citizen who again seeks admission more than 3 or 10 years after the relevant departure or removal date is not inadmissible, even if the non-citizen returned to the United States with or without authorization during the statutory 3-year or 10-year period. 3-year and 10-year periods run from the date of departure or removal, whichever applies without interruption. And a non-citizen's location during the statutory 3-year or 10-year period and the non-citizen's manner of return to the U.S. during this period are irrelevant for purposes of determining inadmissibility. So, This applies to anyone who has triggered the 3 or the 10-year bar, re-entered the US during the 3 or 10-year window, and then applies to adjust status after this period passes. USCIS can no longer cite your physical presence inside the United States during your 3-year or 10-year bar as a reason for denying your adjustment of status application. This does not apply to persons who have the permanent bar or who secured their visa through fraud or misrepresentation. The new policy went into effect on June 24th and will be applied prospectively. In addition, some non-citizens may be able to file a motion to reopen their previously denied application with USCIS using the appeal form. I will include links to the case and policy update in the description below. Also, be sure to watch my latest video on the State Department's recent answers to some of the biggest visa questions, including the NVC and visa interview schedules. I'll include a link to that video here. I'll also continue to bring you as much immigration news as possible, so if you have not yet subscribed, do so now. Stay tuned to watch this next video and I'll see you there.